Merrick Garland and Joe Biden's Department of Justice are fighting tooth and nail to prevent you from exercising your Second Amendment right to carry guns in public for self-defense on U.S. Post Office property. They're so desperate to stop you from exercising your rights, they're literally relying upon, ready for this, folks, 13th and 14th century English laws. You heard me. Guess what? We're going to break it down when we get back. Shocking arguments from Joe Biden and Merrick Garland. Thank God they are going to be gone in about 30 days. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new law review article in the Georgetown Journal of Law and Public Policy, Dangerous but Not Unusual, Mistakes Commonly Made by Courts in Post-Bruin Litigations. I keep referring to this article because I want a lot of people in the Second Amendment community to read this. It's very important to make sure you understand exactly how to analyze Second Amendment cases, and this article will help you do it and apply it to all the modern Second Amendment controversies we are seeing in courts today. Check out my article in the Georgetown Journal of Law and Public Policy. A link to it for free is in the description of this video. All right, folks, so the Firearms Policy Coalition and the Second Amendment Foundation have sued the United States government and Merrick Garland as the Attorney General of the United States in the United States District Court for the Northern District of Texas, challenging the federal government rule and law that says you and I cannot bring a firearm onto the property of the United States Postal Service when we go to the post office. Now, as you know, this is likely unconstitutional for the reasons we're going to get to in one moment, but the focus of this video is not to analyze the entire debate, constitutional fight in court over the post office issue. It's really just to show you the great extent to which this federal government under Joe Biden is so desperate to try to deny you your right to carry a gun in public that they're literally citing to crazy, clearly inapplicable English, you heard me right, English laws that the United States tossed over when we kicked out the redcoats and sent them all scurrying back to England, or in many instances scurrying up to our 51st state, or at least our next territory, like Puerto Rico, the territory of Canada. So, let's begin. As you know, the federal law says you cannot bring a firearm onto post office property when you're getting your mail at the post office. Now, this is absurd because there is simply no way to protect yourself when you go to the post office. There's no security there. There's no armed guards there. There's no metal detectors there. You're literally at risk of being killed by a crazy thug, a terrorist, a criminal. And you are defenseless because most ordinary Americans don't want to violate federal law. They want to comply with the law so they don't bring their guns into the post office. And if, heaven forbid, something bad happens there, they are defenseless. And there's no one in the post office going to protect you. In fact, many post offices are actually located in like general stores, convenience stores, town squares. They don't even have their own building. They just blend in with like a local store or local deli in many instances all across this country. So it's really absurd that this is a gun-free zone because, again, no criminal is going to respect a gun-free zone sign. In fact, the government, believe it or not, basically admits this, and we'll get to that in just a few minutes. But to begin with, it starts off this argument by the Second Amendment Foundation and the Firearms Policy Coalition, who have brought the law with this lawsuit along with some others to challenge this law, starts off basically by pointing out that obviously the text of the Second Amendment is implicated, which means the burden of proof will shift to the government to show historical analog laws to justify this ban. And this, what it is a gun ban law preventing us from carrying guns on post office property. But here's where FPC and the Second Amendment Foundation start their argument. History does not support the constitutionality of the carry ban. Correctly understood, this case calls for the straightforward application of the methodology the Supreme Court has twice now explained in detail in Bruin and Rahimi. As long as the conduct plaintiffs wish to engage in, here, carrying firearms for lawful purposes such as self-defense on property operated by the United States Postal Service, is covered by the plain text of the Second Amendment, then the government bears the burden of showing that the challenged regulation is consistent with the principles that underpin our regulatory tradition, because it is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation in the modern circumstances. The government, the federal government, does not dispute here that carrying firearms at post offices is an activity within the plain text of the Second Amendment. Therefore, the only question in this case, and for this court, is whether the government has shown it is consistent with the history of firearms regulation in this country. It has not done so. So that's a very powerful beginning that the Firearms Policy Coalition and the Second Amendment starts off with, and it's clearly correct. There's no doubt that the text of the Second Amendment is implicated by banning your ability to carry guns on post office property, which means the burden shifts to the government. And again, be very clear, when the burden shifts to the government, it means the government has the duty, the obligation to come forth with the historical analog laws, long-standing, going back to the time of the founding, to justify their modern-day gun control law. And they simply are not able to do that, because the reality is, at the time of the founding, when the Second Amendment was adopted in 1791, the federal government, in fact, there's no evidence whatsoever that there were gun ban laws that applied either to the post offices, the Postal Service in any respect, or even to something that might be analogous to that, like customs houses, which is, of course, buildings, tax collectors, really, that dealt with cargo coming in, either being imported or exported into our local communities, whether it be in Newport, Salem, Massachusetts, Charleston, South Carolina, New York City, the port of New Jersey. You get the idea. This what customs, and there's no evidence at the time of the founding there were these gun bans either in post offices, Postal Service buildings, or customs houses. In fact, as pointed out by the Firearms Policy Coalition and the Second Amendment Foundation in this brief, they really make the point that if anything at the time of the founding, not only were there no restrictions on where you could carry guns outside of the three, or a few places like the three locations identified in the Supreme Court in Bruin, polling places, legislative chambers, and courthouses. Other than those three and a few other maybe analogous things to those three, the reality was there really were not gun bans because people were expected to defend themselves. In fact, if anything, if there was law speaking to the carrying of guns, often it required, you hear what I just said, it required you to bring a gun to a place that might have vulnerable people. Like you were required in many instances to bring your gun to church on Sundays where the community was there and exposed to potential attack by, let's say, marauding Native American Indians. In fact, this brief actually cites to Dave Kopel and to Joseph Greenlee, two scholars of the Second Amendment that write about this. Here's what the brief says on their scholarship about requiring guns to be brought to dangerous places at the time of the founding. There is actually historical evidence that at some places where government business was conducted, like some public meetings, firearm carriage was affirmatively required as a means of safeguarding the operation of the government. See David Kopel and Joseph Greenlee in an article in the Charleston Law Review, 2018. And in others, there were notably no restrictions. For instance, in contrast with polling places, legislatures, and courthouses, the government here has presented no evidence that firearms were banned at customs houses or, as directly relevant to this case, post offices at the founding. So in light of this, what does the federal government and Merrick Garland and Joe Biden try to do to justify these gun bans on the last month that they're in office? Maybe, by the way, side note, one wonders whether or not the Trump DOJ may confess error and actually come out and basically say, yeah, we agree. We agree with the plaintiffs. This is unconstitutional under the Second Amendment, and we're not going to enforce that law. Nevertheless, I don't want to get ahead of ourselves here. Let's just focus on what the Biden administration is doing in defending this law in these last 30 days before they leave office. Specifically, they actually are relying on, ready for this, folks, 14th century, that's the 1300s, 14th century English laws from England that had certain restrictions on where you could bring arms. That's right. That's exactly what they're relying on. They're relying on some royal proclamations. Did you hear what I just said? Royal proclamations. I didn't think the United States had a king, at least before Barack Obama with a pen and a phone, and before Joe Biden. I didn't think we had a king. But yes, they're actually relying on a royal proclamation from the King of England in the year of our Lord, 1313, as well as going back to the well, yet again, to the 1328 English statute known as, you've heard it before on this channel, in fact, the Statute of Northampton, which the Supreme Court in Bruin largely rejected with some exceptions we're going to get to in 1 minute. But let's just turn to what the argument is in this brief as to why these arguments are simply absurd. The Second Amendment plaintiffs argue, quote, government points all the way back to the 14th century, a 14th century English law requiring that every man shall come to Parliament without all force and armor. And they also rely on the 1328 Statute of Northampton. However, neither of these historical statutes supports the rule that lawful possession of firearms can be banned anywhere the government operates. Now, before we explain why these two English laws are clearly not applicable here, I want to remind you of something that's very important for you all to keep in mind if you're talking about the Second Amendment, if you're discussing Bruin, and that is the concurrence written in the Rahimi case in the U.S. Supreme Court in 2024 by none other than Supreme Court Justice Brett Kavanaugh. Because Justice Kavanaugh, in discussing what history is acceptable can be considered, specifically said that courts must exercise caution. They must exercise care and caution to avoid relying on historical laws that our Constitution left behind. Now, what does Justice Kavanaugh mean by that? Obviously, when the United States became its own country and it created its own government, it created its own Constitution, and then it adopted its own Bill of Rights. In many instances, this was embracing some aspects of being an Englishman, the rights of the Englishman. There's some aspects of that, but Americans went far beyond that toward greater freedom than the English have. Like, for example, we don't have a king, right? We got rid of the king. We have a Bill of Rights that specifically allows us to have the right of the people. All people have the right to keep and bear arms, which is indifferent than the English Declaration of Rights, which limited the right to keep and bear arms in England to Protestants, for example. Just an illustration of how the Second Amendment and the entire Constitution expanded freedoms beyond those recognized by England, for example. So when Justice Kavanaugh in Rahimi's concurrence is talking about how we must be careful not to rely on laws that our Constitution, including our Second Amendment, left behind in the dustbin of history, I think what Justice Kavanaugh is largely talking about is, of course, 14th century laws from England, such as royal proclamations, when we don't even have a king, as well as the Statute of Northampton, which is really an anti-terrorism statute. And the good news is, I think the Firearms Policy Coalition and the Second Amendment Foundation down there in this case in the Northern District of Texas did a really good job. Let's see what they have to say about the Statute of Northampton, and then I'll give you a couple additional arguments that I think should be considered in addition to the ones made in this brief. Here's what they argue. Bruin unequivocally held that the Statute of Northampton has little bearing on the Second Amendment adopted in 1791, and that statement certainly holds true here. First, the Statute of Northampton is too old to inform the meaning of the Second Amendment at the founding. Second, its prohibition on going or riding armed centered on large weapons used in combat because handguns had not yet been invented. Third, as the United States Supreme Court has now twice explained, the Statute of Northampton codified the common law prohibition on a phrase, or going armed with malicious intent to terrify others. By the founding, at least, the statute and American law modeled on it were understood not to regulate ordinary lawful carry for self-defense, but only to bar carriage of weapons with the intent to terrify others. It therefore cannot support the carry ban here. Now, I should also add, if you look at footnote number 9 in Nysurpa versus Bruin, it talks about a case called the Sir John Knight's case. Now, what's important is not just the fact that the Sir John Knight's case was rejected in terms of, for the proposition at least, which the anti-gunners are trying to argue it stood for, that you had no right to carry guns in public, period, full stop. That was clearly wrong, and the Supreme Court recognized that to be wrong, as we saw in Bruin, that says you have a fundamental right to carry guns in public. That's what the right to bear arms means. The right to keep means the right to possess arms. The right to bear means the right to carry them in public for self-defense. That's not Mark Smith, Four Boxes Diner talking. That's the U.S. Supreme Court itself. But footnote number 9 in Bruin is particularly important and often goes overlooked by litigators and others analyzing Second Amendment cases, and that is this. Footnote number 9 specifically says that to the extent there is a historical, listen carefully, if there is a historical ambiguity in the record, then a court must opt in favor of the interpretation that is more consistent with the Second Amendment's textual, unqualified command. Meaning if you have two interpretations based on historical analog laws that you're reviewing, and one is more restrictive and one is less restrictive of the right to keep and bear arms, which is a textual right found in the text of the Constitution, obviously, then the Supreme Court has told you to do what they've done in footnote number 1, which is to opt to incorporate and use the interpretation of the historical ambiguity that's more favorable to the unqualified command of your right to keep and bear arms. So again, to the extent there's any argument here or there's any sort of foothold here for the anti-gunners and the government to argue there's a basis for restricting our right to carry guns in post office based on this 14th century law, the Statute of Northampton, at best you have an ambiguity. And again, if there's an ambiguity, the government loses the case because of footnote 9 in Bruin that says if there's a historical ambiguity, freedom wins, restrictions lose. That's just the way it is because there is no real ambiguity at the end of the day because the text of the Second Amendment is clear and unambiguous. And unless there's a clear historical basis for restricting that right, like everyone understands you can't use a gun to commit cold-blooded murder, that is a clear historical exception to the text of the Second Amendment. Unless you have something that extreme, the reality is the text of the Second Amendment controls and you have the right to keep and bear arms. And the government citing to the Statute of Northampton at 14th century law is simply not good enough. So let's now turn to the next argument that the government makes that's simply insane here, relying on a 1313. You heard me right. That's 1313 royal proclamation by the King of England about being allowed or not being allowed to carry guns in Parliament. Let's turn to the argument made by FPC and the Second Amendment Foundation addressing this absurd argument based on this 14th century English law, which is another one in addition to the Statute of Northampton the government tried to rely on here. The government's 1313 royal proclamation forbidding men from coming with force and armor to Parliament is of no more help. First, as with the Statute of Northampton, the statute is simply too remote from the founding of the United States and the adoption of the Second Amendment to be informative about its scope. It is more remote in time from the adoption of the English Declaration of Right and its protection of the right to have arms than the adoption of the Second Amendment is to today. Second, much like the Statute of Northampton, the statute was not focused on the peaceable carry of self-defense arms, but was rather intended for the restraint of armed men from coming to Parliament to disturb the peace. So there you have it, folks. The reality is we should win this case. I don't know if we're going to win. I don't know what's going to happen. One can never predict litigations in the best of circumstances, but we should win this case. We know that the U.S. Postal Service is not providing armed security. They're not providing metal detectors. They're not taking responsibility of our lives. We walk into the post office. We walk into the post office facility. We're on our own. If something bad goes down, we die because we can't protect ourselves. It's just a labeled a gun-free zone when all you're really doing is telling criminals there's victims here, right? But that is not how the law works because as this brief talks about in another place, and as I've talked about in my scholarship, the only thing that makes sense is you have comprehensive security, because if the government is unwilling to put their money and their mouth and their actions to make sure they protect us with actual armed guards and metal detectors and limited points of entry, then they're not taking it seriously, and we have the right to defend ourselves. Because as you know from Supreme Court precedent, as a general matter, the government has no legal duty to protect us unless, of course, we are in their custody, such as if they put us in prison. But outside of that, if we're killed by a criminal, that's on us. The government has no duty to recompense us, has no legal duty to protect us. That's right. To serve and to protect as a general matter is a good logo. It's a good motto, but it is not the law of the land. So there you have it, folks. We'll see what happens. I think we had a good chance to win this, but only time will tell. And we'll see what the Trump administration does with these kinds of cases when they take over the Department of Justice. That'll be something we talk a lot more about when we get into January. But for now, we're going to focus on what's going on in the courts today. So there you have it. Hope you enjoyed today's show. Make sure you subscribe to this channel. We're trying to get to 200,000 subscribers. Feel free to share it with your friends. Don't forget to follow me on X. We have 21,000 followers over on X at Four Boxes Diner. And I look forward to talking to you all again real soon here at the Four Boxes Diner.
Orders up. Table 2A.